I watched through my kitchen window as two men in neon safety vests methodically sprayed something along the walking path that ran directly beside my organic vegetable garden, and my stomach dropped like a stone. The mist from their industrial tanks drifted visibly in the morning breeze, settling over the fence line that separated the HOA common area from my property. I had spent 3 years getting my soil certified organic, countless hours building raised beds, and more money than I cared to admit on compost and natural amendments. Now these guys were casually dousing the area with what I could only assume was commercial herbicide, not 15 feet from where my tomatoes, lettuce, and herbs were thriving in the June sunshine. I bolted out my back door, still holding my coffee mug. "Hey, what are you spraying there?" The older of the two men, probably in his 50s with a weathered face and tired eyes, looked up from his work. "Just weed killer, buddy. We're with Green Solutions Landscaping. The HOA hired us to keep the walking paths clear. How close are you planning to spray to my fence line?" I asked, trying to keep my voice level even though panic was rising in my chest. "We spray along the whole path, man. It's in our contract." He seemed genuinely confused by my concern. "I have an organic garden right there." I pointed at my raised beds where you could clearly see the thriving vegetables. "That spray is drifting directly onto my property. You need to stop right now." The younger guy, maybe in his 20s, shrugged and kept spraying. "We got a job to do." "Take it up with the HOA if you got a problem." I pulled out my phone and started recording. "I'm asking you to stop spraying near my property line. This is going on record." The older man sighed and lowered his sprayer. "Look, we're just doing what we were hired to do. But if you want us to skip this section, you need to call the HOA. We can't just decide to leave parts undone." "Then I'm calling them right now. Please don't spray any more near my fence until this gets sorted out." They exchanged glances and the older one nodded. "We'll move down to the other end of the path. But we're coming back to finish this section unless the HOA tells us otherwise." I was already scrolling through my contacts for the HOA management company's number as they packed up their equipment and headed down the path. My name is William York, and I'd lived in this subdivision in Naperville, Illinois for 4 years. The Pleasant Valley Homeowners Association had always been a minor annoyance, the usual nitpicking about lawn height and mailbox colors, but nothing that really affected my daily life. That was about to change dramatically. The HOA management company phone line rang 4 times before going to voicemail. I left a detailed message explaining the situation and asking for an immediate callback. Then I went inside, set down my now cold coffee, and started documenting everything. I took photos of the spray equipment still visible on the path, the distance from my garden, and close-ups of my plants. I checked my home security camera footage and confirmed it had captured the entire incident. An hour later, my phone rang. The caller ID showed the HOA management number. "Mr. York, this is Deborah with Pleasant Valley Management Services. I received your message about the landscaping work." "Yes, thank you for calling back. I need to know what chemical they're spraying on that path, and I need them to stop immediately. The drift is contaminating my organic garden." There was a pause. "Well, Mr. York, the walking paths are HOA common property. We have the right to maintain them as we see fit. That includes weed management." "I understand that, but you don't have the right to spray chemicals that drift onto my property and damage my garden. That's illegal." "I'll have to check with our board president about this. She handles these types of complaints." "This isn't a complaint. This is a liability issue. If you continue spraying and contaminate my certified organic garden, I'll hold the HOA responsible for all damages, including the cost of recertification. I'm also requesting an immediate copy of the material safety data sheet for whatever chemical they're using. Deborah's tone cooled noticeably. I'll pass your message along, Mr. York. Someone will get back to you. 3 days went by with no response. I called twice more and left messages. Meanwhile, I kept checking my garden anxiously. Some of my lettuce plants near the fence line were starting to show yellow spotting on their leaves. My stomach churned every time I looked at them. On the 4th day, I got a letter in the mail. Not an email, an actual physical letter on Pleasant Valley HOA letterhead. The passive-aggressive formality of it set my teeth on edge before I even opened it. Dear Mr. York, the Pleasant Valley Homeowners Association Board of Directors has received your concerns regarding our standard landscape maintenance practices. Please be advised that the association has full authority to maintain common areas, as outlined in the CC and Articles you agreed to upon purchasing your property. The walking paths constitute common area property, and the association exercises its rights to manage vegetation on these paths in accordance with professional landscaping standards. We have contracted with Green Solutions Landscaping, a licensed and insured company, to perform these services. All chemicals used are EPA approved and applied according to manufacturer specifications. If you have concerns about your personal garden, we recommend you install appropriate screening or barriers to protect your plants. The association will continue its scheduled maintenance as planned. Sincerely, Margaret Anderson, Board President, Pleasant Valley HOA. I read the letter 3 times, my anger building with each pass. Not only were they refusing to stop, they were essentially telling me it was my problem to solve. Margaret Anderson. I'd seen her at a few HOA meetings. A woman in her late 40s with an aggressive helmet of highlighted blonde hair and the kind of tight smile that never reached her eyes. She drove a white Mercedes SUV with a live, laugh, love bumper sticker, and was known in the neighborhood for leaving passive-aggressive notes about trash cans left out too long. I immediately called a lawyer. Actually, I called 3 lawyers before I found one who specialized in property law and had experience with HOA disputes. His name was Robert Chen, and his office was in downtown Naperville. "Come in tomorrow at 2, he said after I explained the situation. "Bring all your documentation, the letter, photos, everything." Robert's office was small but organized, with law books lining one wall and diplomas from Northwestern on another. He was maybe 10 years older than me, early 40s, with sharp eyes that missed nothing as I spread out my documentation on his desk. "Walk me through this from the beginning," he said, pulling out a legal pad. I explained everything: the initial spraying, my confrontation with the landscaping crew, the HOA's dismissive response, and the damage I was already seeing in my garden. "What's the organic certification worth to you?" Robert asked. "In terms of actual monetary value." "I sell produce at the local farmers market. The organic certification lets me charge premium prices. Between the certification cost, the 3 years of following organic practices to qualify, and the lost revenue if I lose certification, we're probably looking at $15,000 to $20,000. Robert nodded, making notes. "And you're certain the spray drift is causing the damage?" I took leaf samples to a local agricultural extension office. They're testing them now, but the timing is too coincidental. Healthy plants one day, chemical exposure, yellowing and dying leaves the next day. "Good. That's exactly the kind of documentation we need." Robert leaned back in his chair. "Here's the situation. The HOA is technically correct that they have the right to maintain common areas. However, they don't have the right to damage your property in the process. Illinois law is clear on this. The issue is proving causation and getting them to stop before more damage occurs. So what do we do? First, I'm going to send them a cease and desist letter. It'll put them on notice that we're serious and that continued spraying will result in legal action. Second, we need to document every bit of damage. Keep taking photos. Keep those plants even if they die. Get the test results from the extension office. Third, we're going to file for a temporary restraining order to stop any further spraying until this is resolved. How much is this going to cost me? Robert gave me a sympathetic look. I'm not going to lie, litigation is expensive, but HOA cases often have attorney fee provisions that favor the homeowner if you win. And frankly, you have a strong case. They've been notified of the problem, and they're choosing to continue anyway. That's willful damage to property. I signed the retainer agreement and wrote a check that made my hand shake slightly. But as I left Robert's office, I felt something I hadn't felt in days: hope. The cease and desist letter went out the next day via certified mail. Robert also sent copies to Green Solutions Landscaping and the HOA Management Company. 2 days after that, I got a phone call from a number I didn't recognize. "Is this William York?" The voice was female, tight with barely controlled anger. "Yes, who's this?" "Margaret Anderson. I'm the president of your HOA board. I got a very concerning letter from a lawyer claiming we're damaging your property." "That's correct. Your landscaping company sprayed herbicide that drifted onto my organic garden and contaminated it. I asked you to stop, and you refused." "Mr. York, I don't appreciate being threatened with legal action over routine maintenance. Do you have any idea how much it costs to maintain this community? We have a budget to follow, and we can't just accommodate every homeowner's personal preferences. This isn't about preference. It's about you damaging my property. If you continue spraying near my fence line, you'll be liable for all damages." Margaret's voice rose. "You know what? I'm sick of entitled homeowners like you thinking the rules don't apply to them. Everyone else in this community manages to follow the guidelines without making demands. Maybe you should have thought about your precious garden before you bought in an HOA community." "Margaret, I'm documenting this call. Your company is damaging my property. I've notified you of the damage and you're choosing to continue. That makes you liable. Document whatever you want. We'll see you in court, Mr. York. And good luck paying your legal bills when we assess you for our attorney costs. The CC and Articus say we can do that, you know." She hung up. I immediately called Robert and relayed the conversation. "Perfect," he said, which wasn't the response I expected. "She just confirmed that she's aware of the damage and intends to continue anyway. That's going to help us. How's your garden looking?" "Worse. More plants are showing damage. I might lose the entire lettuce crop." "Document it all. We're filing for the restraining order tomorrow." The temporary restraining order hearing was scheduled for the following Tuesday at the DuPage County Courthouse. Robert assured me these were usually quick hearings, but I should be prepared to testify about the damage. I showed up in my best suit, which I usually only wore to weddings and funerals. Robert met me outside the courtroom, looking calm and professional with a leather briefcase full of documentation. "The HOA will probably have their attorney here," he warned me. "Don't let them get under your skin. Just answer questions honestly and stick to the facts." The HOA's attorney turned out to be a silver-haired man named Preston Hughes, who had the kind of expensive suit that screamed corporate law firm. Margaret Anderson sat behind him in the gallery, her arms crossed, and her face set in a scowl. Judge Patricia Williams presided. A no-nonsense woman in her 60s who had a stack of files on her bench that suggested she had a long day ahead of her. This is a motion for temporary restraining order in the matter of York versus Pleasant Valley Homeowners Association, she said, looking over her reading glasses at both tables. Mr. Chen, you're the petitioner, Robert stood. Yes, Your Honor. My client, William York, is asking the court to temporarily enjoin the Pleasant Valley HOA from spraying herbicide near his property line, pending a full hearing on the matter. On what grounds? Property damage, Your Honor. The HOA has been spraying commercial herbicide along a walking path that directly borders my client's property. Despite notification that the spray is drifting onto his land and damaging his certified organic garden, the HOA has refused to stop or modify their spraying practices. Judge Williams looked at the other table. Mr. Hughes, Preston Hughes stood with the fluid motion of someone who spent a lot of time in courtrooms. Your Honor, this is an overreach by the petitioner. The Pleasant Valley HOA has every right to maintain its common areas, including managing vegetation on its walking paths. Mr. York's garden is his personal responsibility. If he's concerned about spray drift, he should install protective barriers. Your Honor, may I call my client to testify? Robert asked. Keep it brief, Mr. Chen. I have 12 more cases this morning. I took the witness stand and was sworn in. Robert walked me through the events. The spraying, my immediate objection, the documented damage, the HOA's refusal to stop. Mr. York, can you quantify the damage to your garden? Robert asked. So far, I've lost approximately 40% of my lettuce crop, and several tomato plants are showing signs of herbicide damage. But the bigger issue is that this garden is certified organic. I've spent 3 years following strict protocols to get that certification. Any herbicide contamination could invalidate it, which would cost me thousands in lost certification fees and lost revenue from farmers' market sales. You have documentation of this damage? Yes. I have photos showing the progression of damage, starting from the day after the spraying. I also sent leaf samples to the University of Illinois Extension Office for testing. Their preliminary results show the presence of glyphosate, which is not permitted under organic certification standards. Preston Hughes stood for cross-examination. Mr. York, isn't it true that you chose to plant your garden right next to an HOA walking path? I planted my garden on my property, yes. The walking path has been there since before I moved in. And you were aware when you moved in that the HOA maintains those paths? I was aware they maintain the paths. I wasn't aware they would spray herbicide in a manner that contaminates neighboring properties. But you agreed to the HOA's CC and Articus when you purchased your home, correct? I did. And those CC and Articus give the HOA authority to maintain common areas. They give the HOA authority to maintain their property, not to damage mine. Hughes frowned. No further questions. Margaret Anderson took the stand next, and I could see her practically vibrating with righteous indignation. Miss Anderson, can you explain the HOA's position on this matter? Hughes asked. Certainly. We have a responsibility to all homeowners in Pleasant Valley to maintain the community in a safe and attractive manner. That includes controlling weeds on our walking paths. Mr. York is the only person who has complained about our standard maintenance practices. We use a licensed, professional company that applies EPA-approved chemicals according to all regulations. This is simply Mr. York trying to dictate how the entire community is managed based on his personal preferences. And what would be the impact on the community if you were forced to stop this maintenance? Our paths would become overgrown with weeds. It would look terrible and potentially create safety hazards. Plus, we'd be in breach of our contract with Green Solutions, which could result in penalties. All of this would come out of the community budget, meaning everyone's dues would have to increase to cover the costs. Robert stood for cross. Miss Anderson, when did you first learn that the herbicide spraying was damaging Mr. York's garden? He called the management company about a week and a half ago. And what did you do in response to that information? Margaret's jaw tightened. I investigated the claim and determined that the HOA was within its rights to continue the maintenance. Did you consider any alternatives, such as having the landscaping company avoid spraying near Mr. York's fence line, or using different methods to control weeds in that specific area? We shouldn't have to change our practices for one person. That's not what I asked. Did you consider alternatives? No. So when Mr. York notified you that your activities were damaging his property, you decided to continue those activities without even exploring whether there were ways to avoid the damage. The paths need to be maintained. Yes or no, Miss Anderson? Did you explore alternatives? No. Robert nodded. No further questions. Judge Williams tapped her pen on her desk. Mr. Hughes, does the HOA have any evidence that modifying their spraying practices near Mr. York's property would be unreasonably burdensome? Your Honor, it would set a precedent that could lead to numerous similar requests throughout the community. That's speculation, not evidence. Mr. Chen, do you have the test results from the Extension Office? Robert pulled out a document. Yes, Your Honor. They're preliminary but conclusive. The leaf samples show elevated levels of glyphosate-based herbicide. The judge reviewed the document for a moment. Here's my ruling. I'm granting a temporary restraining order prohibiting the Pleasant Valley HOA from spraying any herbicide within 25 feet of Mr. York's property line, pending a full hearing on the merits. The HOA may continue to maintain its walking paths through other means in that area. Mr. Chen, file your complaint within 10 days. We'll schedule this for a full hearing within 60 days. That's my order. She banged her gavel and it was over. Margaret Anderson looked like she wanted to explode, her face flushed red. Preston Hughes calmly packed his briefcase, showing no emotion at all. Outside the courthouse, Robert clapped me on the shoulder. Good job in there. The TRO will hold them off while we build the full case. What happens now? Now, I file a formal complaint for property damage and injunctive relief. We'll need to fully quantify your damages, including the cost to recertify your garden if necessary, and we'll push for attorney's fees. Over the next 2 weeks, I carefully documented every aspect of my garden damage. The Extension Office's final report confirmed glyphosate contamination in both the soil and plant tissue samples. My organic certifying agency sent me a letter explaining that I would need to undergo the full 3-year transition period again if I wanted to maintain certification, along with extensive soil testing to prove the contamination had dissipated. The cost would be approximately $8,000, not including the lost revenue from being unable to sell organic produce during that period. I also discovered something interesting while going through my community documents. The HOA had conducted a survey 2 years earlier about community concerns, and several residents had mentioned worries about chemical spraying near children's play areas and walking paths. The board, including Margaret Anderson, had dismissed these concerns in their meeting minutes with a brief note that all chemicals used are EPA approved and professionally applied. Robert's formal complaint laid out the case in detail: negligence, nuisance, trespass, and violation of Illinois environmental laws. We were asking for actual damages of $23,000, covering the certification costs, lost revenue, and decreased property value. We also asked for punitive damages and attorney's fees. The HOA's response came 3 weeks later, and it was aggressive. They denied all allegations, claimed I had failed to properly protect my garden, and filed a counterclaim alleging that I was harassing the board and interfering with the HOA's duties. They asked for their attorney's fees and costs, plus a declaration that they had the right to continue their maintenance practices unchanged. "This is typical," Robert said when we reviewed their response. "They're trying to intimidate you into settling for less than you deserve. Don't worry about the counterclaim. It's baseless." The discovery phase began, which meant both sides requested documents from each other. Robert requested all HOA communications about the spraying, all contracts with Green Solutions Landscaping, all meeting minutes discussing maintenance practices, and all complaints from other residents about chemical use. What we got back was eye-opening. First, the contract with Green Solutions specified that they were supposed to notify all residents at least 48 hours before any chemical applications. That had never happened. Second, there were 15 other complaints over the past 3 years about the herbicide spraying, ranging from concerns about pets getting sick to reports of chemical odors near homes. Margaret Anderson had personally responded to many of these complaints with dismissive emails telling residents that their concerns were unfounded and that they needed to trust the board's judgment. Most damning was an email chain between Margaret and another board member, Susan Wright, 2 weeks before my incident. Susan had suggested they consider switching to organic weed control methods in response to resident concerns. Margaret's response was enlightening. "Absolutely not. These natural methods cost twice as much and don't work as well. If people don't like how we maintain the community, they can move somewhere without an HOA. We're not here to cater to every special request." Robert practically glowed when he read that email. This is gold. It shows a pattern of ignoring legitimate safety concerns and a willful disregard for homeowners' property rights. The deposition phase was next. I sat in a conference room at Preston Hughes's law firm while he questioned me for 4 hours about everything from why I chose to plant an organic garden to whether I'd properly maintained my fence line. It was exhausting and felt pointless, but Robert had prepared me well. I stuck to simple, factual answers and didn't let Hughes bait me into emotional responses. Margaret Anderson's deposition was far more entertaining. Robert questioned her methodically, getting her to confirm detail after detail about the HOA's practices. When he asked her about the email dismissing Susan's suggestion for organic maintenance, Margaret became defensive. "That email was taken out of context," she said, her voice sharp. "What context would make if people don't like how we maintain the community? They can move appropriate when discussing legitimate property damage concerns," Robert asked. "I was simply pointing out that homeowners agree to HOA governance when they purchase." "Did you investigate whether organic methods would actually be feasible? I know they're more expensive and less effective." "How do you know that? It's common knowledge. Did you get quotes from landscaping companies? Read studies? Consult with experts?" Margaret crossed her arms. "I didn't need to. I've been on this board for 6 years. I know what works." Robert let that answer sit in the record for a moment before continuing. "After Mr. York notified you his garden was being damaged, did you visit his property to assess the situation?" "No." "Did you ask anyone else to assess it?" "No." "Did you ask Green Solutions whether they could modify their spraying pattern to avoid his fence line?" "No, because we shouldn't have to change our practices for one person's hobby." "You consider a certified organic garden that generates income just a hobby. It's not a commercial operation. He's growing vegetables in his backyard. But he sells those vegetables, correct, at some farmer's market, apparently. So it's a business, a small one. But still a business that you damaged by allowing herbicide to contaminate his property, Preston Hughes interrupted. Objection, argumentative. Withdraw the question, Robert said smoothly. Miss Anderson, are you aware that Illinois law prohibits property owners from engaging in activities that damage neighboring properties? We weren't damaging anyone's property. We were maintaining our own property, even though the herbicide drifted onto Mr. York's land. That's not our responsibility. Who is responsible for where spray drift goes? Margaret's face was getting red again. The landscaping company. But the HOA hired them, correct? Yes. And the HOA directed them to spray near property lines. We directed them to maintain the paths, without any consideration for neighboring properties, with the expectation that they would follow professional standards. Robert made another note. Did you ever speak directly with Mr. York about this issue? Yes, I called him after he sent that threatening lawyer letter. Can you describe that conversation? Margaret's expression suggested she realized she'd made a mistake. I told him that we couldn't accommodate every individual request. Did you tell him you'd see him in court? I may have said something like that. Did you tell him the HOA would assess him for attorney's fees? I explained that the CC and Articus allow for that, yes. So your response to a homeowner reporting property damage was to threaten him with legal fees. I didn't threaten him. I was explaining his obligations under the CC and Articus. The deposition went on for another 2 hours, but Robert had gotten what he needed. Margaret had confirmed that the HOA had received multiple complaints about the spraying, had never investigated alternatives, had ignored my specific concerns about damage, and had essentially told me to deal with it or face consequences. As spring turned to summer, my garden continued to suffer. The tomato plants near the fence line never recovered and had to be pulled out. The lettuce was a total loss. Even plants several feet away from the fence showed stunted growth. I photographed everything and kept meticulous records. The preliminary hearing was scheduled for August, but 2 weeks before the court date, Robert called me with news. The HOA wants to settle, he said. For how much? $15,000, plus they'll agree to stop spraying within 30 feet of your property line permanently. I did the math in my head. We were asking for $23,000 plus punitive damages. That's not enough to cover my actual damages. I know. I told them that, but I wanted to run it by you anyway. Litigation is always a risk, and this would give you certainty. What do you think we can get if we go to trial? Robert was quiet for a moment. Honestly, I think we have a very strong case. The email evidence is damning. Margaret's deposition was a disaster for them, and we have solid documentation of damages. I think we could get full damages plus attorney's fees, possibly punitive damages. But trials are unpredictable. Let's counter at $25,000, no attorney's fees, and the permanent buffer zone. If they don't take it, we go to trial. That's aggressive. So is poisoning someone's garden and then telling them to deal with it. Robert countered at $25,000. The HOA came back at $18,000. We held at $25,000. They came back at $20,000 final offer. Take it, Robert advised. $20,000 plus the permanent restriction is a good result. You'll be able to recertify your garden and still come out ahead. I thought about it for a day. Part of me wanted to push forward to trial, to make Margaret Anderson admit in open court that she'd been wrong. But the practical side of me recognized that $20,000 would cover all my actual damages with some left over, and the permanent buffer zone would protect my garden going forward. Okay, I told Robert, but I want one more thing. I want a written apology from the HOA board, signed by Margaret Anderson, admitting that their spraying damaged my garden and that they should have addressed my concerns when I first raised them. They'll never go for that, Robert said. Then we go to trial. Robert called me back 3 hours later. You're not going to believe this. They agreed. Margaret fought it, but the other board members overruled her. They're so sick of this case and the legal fees that they just want it done. The settlement agreement was signed 2 weeks later. I received a check for $20,000, which covered my recertification costs, lost revenue, and then some. The HOA agreed to a permanent 25-foot buffer zone along my property line, where they would only use non-chemical weed control methods. And I got my apology letter on Pleasant Valley HOA letterhead, signed by all 5 board members. But the story didn't end there. 2 months after the settlement, I got a call from Susan Wright, the board member who had suggested organic methods in that email. She asked if I would meet her for coffee. We met at a Starbucks in downtown Naperville. Susan was in her early 50s with graying hair and a tired but kind face. "I wanted to thank you," she said after we sat down with our drinks. "For what?" "For standing up to Margaret. I've been on the board for 3 years, and she's made it impossible to get anything done that doesn't align with her vision. This lawsuit opened a lot of eyes." "What do you mean?" Susan smiled. "There's going to be a recall election next month. Several homeowners have filed a petition to remove Margaret from the board. After your case, people started asking questions about other decisions she's made. Turns out she's been pretty heavy-handed with a lot of residents." "Good," I said, and meant it. "I'm actually considering running for board president if the recall succeeds. I'd like to take the HOA in a different direction, more responsive to homeowners, more environmentally conscious. Would you be willing to help? Maybe serve on a green spaces committee or something?" I thought about it. A few months ago, I would have said absolutely not. I was done with the HOA and just wanted to be left alone. But Susan seemed genuine, and maybe there was an opportunity to make sure what happened to me didn't happen to anyone else. "Maybe," I said. "Let's see how the recall election goes first." The recall election happened in October. Margaret Anderson fought it tooth and nail, sending out angry letters to all homeowners claiming the recall was orchestrated by people who wanted to destroy property values. She held a meeting where she ranted for 30 minutes about ungrateful residents and all the work she'd done for the community. It backfired spectacularly. The recall passed with 78% of the vote. Margaret was out. Susan Wright won the special election for board president and immediately began making changes. The first thing she did was renegotiate the contract with Green Solutions Landscaping to include organic weed control methods on all walking paths and common areas. It cost more, but several homeowners, myself included, volunteered to pay a slight increase in our dues to cover it. The second thing Susan did was establish a formal complaint resolution process, so residents had a clear path to raise concerns without being dismissed or threatened. She also implemented a transparency policy requiring the board to publish detailed meeting minutes and financial reports online. My garden slowly recovered. I worked with the organic certifying agency to develop a remediation plan, which included multiple rounds of soil testing and careful documentation that no further contamination had occurred. It took the full 3 years, but in June of the following year, my garden was recertified organic. I started selling at the farmer's market again, and my business grew. People had heard about the lawsuit, some from news coverage in the local paper, and there was a surprising amount of support for what I'd done. "You're the guy who stood up to the HOA" became a common greeting at my market stall. I did end up joining Susan's Green Spaces Committee. We worked on converting more common areas to native plantings that required less maintenance, installed rain gardens to help with drainage issues, and created a community composting program. It was actually satisfying to be part of making the neighborhood better rather than just fighting against it being made worse. Margaret Anderson moved out of Pleasant Valley about 6 months after the recall. I heard through the neighborhood grapevine that she'd bought a condo in a high-rise in downtown Chicago, somewhere without an HOA where she could just be a regular resident. I hoped for the sake of her neighbors that she'd learned something from the experience, but I wasn't holding my breath. One evening in late summer, about 2 years after the initial incident, I was working in my garden when my neighbor from across the walking path, an older gentleman named Tom who I'd chatted with occasionally, came over to the fence. "William, you got a minute?" he asked. "Sure, what's up?" "I just wanted to say I'm glad you fought them. I've been living here for 12 years and Margaret made this place miserable. Always some new rule, always someone getting fined for some petty nonsense. When you sued, I thought you were crazy. HOAs always win, right? But you proved they don't have to. You proved we don't have to just accept whatever the board decides." "Thanks, Tom. Though I'll admit there were times I wasn't sure it was worth it. It was. My grandson has asthma. I used to worry every time they sprayed those chemicals, wondered if he was breathing that stuff in when he visited. Now I don't have to worry about that anymore. So thank you." After Tom went back inside, I stood in my garden for a while, looking at the thriving plants. The tomatoes were heavy with fruit, the basil was fragrant and lush, and the lettuce was perfect. More importantly, I knew exactly what had gone into growing them. No mystery chemicals, no contamination, just sun and water and good soil and time. The whole experience had taught me something important. HOAs exist because, in theory, shared governance of shared spaces makes sense. But that system only works when the people in charge remember they're supposed to serve the community, not rule it. When board members start thinking of themselves as enforcers rather than neighbors, when they prioritize convenience and cost over people's legitimate concerns, that's when the system breaks down. Standing up to the HOA had cost me time, money, and stress. But it had also changed things for the better, not just for me but for everyone in Pleasant Valley. The new board was far from perfect, but at least they listened. At least they tried to balance different interests. At least they recognized that their job was to make the community livable for everyone, not to impose one person's vision of how things should be. I picked a ripe tomato, still warm from the sun, and took a bite. It tasted like victory. The legal bills had been real, even with the settlement covering most of Robert's fees. I still ended up paying about $3,000 out of pocket when everything was said and done. But standing in my garden, with organic certification restored and a freezer full of vegetables I'd grown and frozen, with neighbors who no longer lived in fear of petty tyranny from their HOA board, it felt worth it. I also learned a lot about the law in the process. Illinois property law is pretty clear about nuisance and trespass. You can't damage someone else's property just because you're doing something on your own property. That principle extends to things like noise, pollution, and yes, herbicide drift. The fact that the HOA owned the land where the spraying occurred didn't give them carte blanche to ignore where that spray was going. The case also highlighted something I hadn't fully understood before: the importance of documentation. If I hadn't taken those initial photos, if I hadn't gotten the soil tested, if I hadn't recorded my conversations and kept copies of every email and letter, the case would have been much harder to prove. Margaret could have claimed the damage was from something else, or that I was exaggerating, or that I'd never properly notified them. The documentation made my case airtight. Robert Chen became a friend through the process. We still meet for lunch occasionally, and he's told me that my case helped him win 2 other similar disputes with different HOAs in the area. Apparently, word got around in the local legal community that homeowners could successfully fight HOAs when the HOA was genuinely in the wrong, and that emboldened other people to stand up for their rights. One of those cases involved a family whose child had severe allergies, and the HOA insisted on planting trees the child was allergic to right next to their property. Another involved an HOA that tried to force a homeowner to remove solar panels that were perfectly legal under Illinois law. In both cases, the HOAs backed down once they realized they'd face the same kind of scrutiny and potential liability that Pleasant Valley had faced. The farmers market business continued to grow. By the 3rd year after the lawsuit, I was making enough from vegetable sales that I considered whether I could do it full-time. I decided against it, mainly because I liked my day job as a systems analyst for a tech company in Chicago, but it was gratifying to know the option existed. I also started speaking at local gardening clubs about organic growing methods and about property rights. The story of the lawsuit always came up, and I tried to use it as a teaching moment. Stand up for yourself when you're in the right, but also pick your battles carefully. Document everything. Find good legal help. And remember that the goal isn't just to win, but to create positive change. The Pleasant Valley walking path where all this started got a makeover under Susan's board leadership. They installed native prairie plants along the edges, which were naturally resistant to weeds and created habitat for butterflies and bees. The path itself was maintained by hand pulling the few weeds that did pop up, which was more labor-intensive, but eliminated any chemical use. Several residents, myself included, volunteered for path maintenance days where we'd spend a few hours pulling weeds together. It became a community-building activity, rather than just another line item in the maintenance budget. Margaret's replacement on the board, a younger guy named Jason who worked in environmental consulting, became a champion for sustainable practices. He pushed for LED streetlights, started a neighborhood tool library so people could share equipment instead of everyone buying their own, and organized community workdays for various projects. The HOA started to feel less like an adversary and more like what it was supposed to be: neighbors working together to maintain shared spaces. That's not to say everything became perfect. There were still occasional disputes about fence heights and paint colors and all the usual HOA nonsense. But the tone had changed. Instead of imperial decrees from on high, there were conversations. Instead of threats and fines, there were attempts to find compromise solutions. It wasn't revolutionary, but it was a huge improvement. I ran into Preston Hughes, the HOA's attorney, at a local restaurant about a year after the settlement. It was awkward for a moment, but then he came over to my table. "I wanted to say you were right," he said. "I was just doing my job, representing my client, but Margaret made that case impossible to defend. Between you and me, I advised her to settle much earlier. She wouldn't listen." "I appreciate you saying that," I told him. "Good cases make good law," he said. "Your case is now cited in HOA disputes across Illinois. You set a precedent that HOAs can't just ignore property damage they cause. That's a good thing." After Preston left, I thought about that. I hadn't set out to set legal precedent. I just wanted to protect my garden. But sometimes standing up for yourself has ripple effects you don't anticipate. My garden became something of a neighborhood attraction. People would walk by and stop to admire it, and I got in the habit of chatting with them, sharing tips, sometimes giving away extra produce. Several neighbors started their own vegetable gardens, inspired by what they saw. None of them had the resources or inclination to pursue organic certification, but they were growing their own food and learning about where it comes from, and that felt important. One of those neighbors was a single mom named Rachel, who had 3 kids under 10. She told me that starting a garden gave her kids something to do outside that didn't involve screens, and they were actually eating vegetables they'd grown themselves. She thanked me for fighting the HOA because she'd been worried about the chemical spraying near where her kids played, but hadn't known how to address it. That conversation stuck with me. My lawsuit hadn't just been about my garden. It had been about creating a healthier, safer environment for everyone in the community. The fact that the HOA now used organic methods meant kids could play on those paths, people could walk their dogs, and nobody had to worry about chemical exposure. That was worth more than any settlement check. The organic certification process, the second time around, was actually easier than the first time, because I knew what to expect and had systems in place. The inspectors were thorough but fair, and when the approval came through, it felt like closing a chapter. The contamination was behind me, the garden was fully restored, and life could move forward. I framed the settlement agreement and the apology letter and hung them in my garage. Not because I wanted to gloat, but because I wanted to remember what I'd learned. Sometimes you have to fight for what's right. Sometimes that fight is expensive and stressful and makes you question whether it's worth it. But when you're genuinely in the right, when you have the facts on your side, when you're willing to see it through, you can win even against institutions that seem more powerful than you. The Pleasant Valley HOA exists today as a functional organization that manages common areas, organizes neighborhood events, and handles the various administrative tasks that come with a planned community. Susan Wright served 2 terms as president before stepping down, and the current board maintains the more collaborative, responsive approach she established. They still use organic methods for landscape maintenance. They still have a clear complaint resolution process. And most importantly, they treat residents like partners rather than subjects. As for me, I'm still in my house in Naperville, still growing my organic garden, still selling at the farmer's market. The tomatoes get better every year as the soil improves. The herbs are lush and fragrant. The lettuce grows in abundant waves from spring through fall. And every time I look at that fence line where the HOA used to spray, where the plants used to yellow and die, I see healthy growth and know that I made a difference. That's the real victory, not the settlement money or the legal precedent, or even the satisfaction of proving I was right. It's knowing that I helped create a better environment for myself and my neighbors, and that other people in other communities might benefit from what I went through. Would I do it again? Absolutely. Would I recommend that others stand up to their HOAs when the HOA is wrong? Without hesitation. But I'd also tell them to be prepared for a fight, to document everything, to get good legal help, and to remember why they're fighting in the first place. In the end, it's about more than property rights or garden certification or legal precedent. It's about the principle that people should be able to live peacefully on their own property without fear that those charged with managing the community will damage what they've built. It's about accountability and common sense, and remembering that rules exist to serve people, not the other way around. My organic garden thrives today, chemical-free and productive, a testament to what can be achieved when someone refuses to accept that things have to stay broken just because they've always been that way. And every tomato I harvest, every bunch of basil I cut, every head of lettuce I pick, reminds me that standing up for what's right, even when it's hard, even when it costs you, is always worth it in the end.